Hey everyone, Chris here. Thanks for checking out the podcast. If you're enjoying it and learning something along with us, please consider becoming a supporting patron at patreon.com/ateacherhistory. Or you could leave a rating and review on iTunes. It would be a huge help. If you'd like to raise your hand and participate along with us, you can find us on Facebook, Twitter, @ateacherfist, or shoot me an email, chris@ateacherhistory.com. All right, let's get on to the next episode. Hello, and welcome into A Teacher's History of the United States. Thanks so much for joining us again today. This is a special bonus episode for you listeners out there. It is an election season special, one of a few that Bill and I plan on doing here in the next 25 days as we lead up to the 2020 election. And if you're listening to this in the future, don't tell me what happens, because I'm pretty excited for it. But with no further ado, I welcome back my good friend and podcast contributor, legal extraordinaire, Mr. Bill Gorman. How you doing, bud?
What it is, Chris.
Great. I'm not sure what that means, but I assume that that's good.
Well, absolutely. Anytime we get to talk SCOTUS, I'm in.
Sounds good. I just don't quite know the lingo.
Oh, we'll get there. I'll define it.
In St. Louis, where you hang. Okay, cool. So, Bill, why don't you just take a brief moment and explain to everybody what this episode is all about, and maybe a preview of future episodes you and I will be doing together to help educate the electorate prior to the 2020 election.
Yeah, for sure. I mean, this is something that I brought to your attention and Zach's attention, who I also think, don't shortchange Zach. I think he's going to join us on a couple of those.
He may. For full disclosure to the listener, Zach has a tendency to get really worked up over certain things and doesn't trust himself to leave his very subjective opinions out of some of these conversations. So for you, because we don't want subjectivity to run the day, you can tune into all types of political podcasts to get people's opinions who are no more or less valuable than mine or yours. So we're not going to do that. But that's why Zach isn't on this one.
So Zach notwithstanding, we had talked about how with the election right around the corner, and we're recording on Sunday, October 11th. So you said about a little over 3 weeks till Election Day. And we were talking about what may be particularly prescient to listeners, to folks who are absorbing the news on an everyday basis, especially this election cycle news. And one of the areas that we thought was particularly prescient right now, especially considering that the Amy Coney Barrett hearings start what would be tomorrow, Monday, October 12th, is the Supreme Court. Always a battle in an election year, but particularly this year because of the nature of the timing of the situation right before the election. So we're going to talk through the history of the court today, like Chris said, but the other two areas that we're going to address ahead of the election are going to be on the Electoral College, which obviously, if you've listened to this podcast, you've heard us talk a little bit about during the framing Constitutional Convention about this thing called the Electoral College, how we don't elect the president technically on the basis of a popular vote, rather through a system of electors, which we, of course, will address the democratic nature of that system in that podcast. And then, finally, we're going to do an episode on the power of incumbency. And I know Chris was particularly excited about that episode.
Yeah, whenever I would teach AP government, we would do a section specifically on the incumbency advantage and just how much of an enormous advantage it is to be the sitting president when running for re-election, and history bears that out. And so we'll talk about some of the reasons why and what the history tells us about that. Of course, we'll be recording that before the the election, the 2020 election, so we don't know what's going to happen. And so we'll just be truly taking a historical look at it. And then after the election, you can take the results of the election and that episode and sort of put two and two together and, see what happens. So, Bill, you want to just dive right into it here?
Yeah, let's do it.
Okay,
So,
great.
unless you have been living under a rock for the last month or so, and let's be real, for much longer than that, you will have at least heard attenuated arguments about the future of the Supreme Court. For purposes of this podcast, you may hear us, you've already heard me refer to the Supreme Court by the acronym SCOTUS, or Supreme Court of the United States. This adjudicative body is under an even greater than normal amount of scrutiny, given it is a presidential election year, because of the recent passing of Associate Justice Ruth Bader Ginsburg. Ruth Bader Ginsburg led an inspiring life. She was a pioneer for gender equality and one of the primary architects to overturn laws that discriminated on the basis of sex. Later in life, Ginsburg became a cultural icon, especially for young women, earning the moniker the Notorious RBG. This podcast, though, is not focused on the extraordinary life and accomplishments of RBG. Rather, we felt it was incumbent upon us to provide a greater historical context around the ensuing political and societal battle around filling the vacant seat that was vacated by Ruth Bader Ginsburg. This includes recent speculation about terms you've probably heard of being thrown around, like court packing. By the end of this, albeit out of the narrative podcast, we believe you will be equipped to cut through the posturing you see on Twitter or hear on the news, and instead have a better understanding of what the court as an institution means, what changes to the court might be radical, and how the court has been and likely will continue to be an evolving body. Now, to understand the politically charged narratives of both Republicans and Democrats today, we need to back all the way up to 1789, and in a moment, Chris will back up even a little bit farther. Presently, though, you may be reading articles or hearing from your friends, family, or coworkers that SCOTUS is comprised of 8 associate justices and 1 chief justice, for a total count of 9. They would, of course, be correct. And the Constitution, Article 3 to be exact, details the constitution, pun intended, of a Supreme Court. So, Chris, could you please identify where in the Constitution it describes that SCOTUS is to consist of 8 associate justices and 1 chief justice?
Do you really want me to try?
You're wrong. In any event, you're wrong. I got you again. That was obviously a trick question. Nowhere in the Constitution do the founders explicitly state the number of justices there are to be at any given point in time. And so with that, we're going to pivot, and Chris is going to provide a bit more of a framework around what that meant at the time.
Yeah, thank you, Bill, and I'm really glad we're doing this episode. And rest in peace, Ruth Bader Ginsburg, as someone who has 2 daughters, women like her. I have a huge amount of respect for them. So, you mentioned that nowhere in the Constitution is it written that there are 9 justices, and you would be correct. And I know that one of your favorite pastimes is answering your own rhetorical questions. So you're welcome for allowing you that opportunity. And that's because the Article 3, as you mentioned, of the Constitution is what outlines the judiciary. Article 1 is the legislative branch. Article 2 is the executive. Article 3 is the judiciary. I used to tell students it's easy to remember by LEJ is leg, like short for legislative, and that sort of allows you to remember it, LEJ. And there's not much in Article 3 of the Constitution, and that's for a very specific reason. During the debates over the Constitution, there were some very real questions that couldn't totally be answered by the men who were writing the Constitution at the convention. Like, should there be a federal judiciary? If there is to be a federal judiciary, how expansive should it be? Also, where is their jurisdiction? I mean, these are like huge questions, really important questions. And to be fair, they were solving like a lot of other really important problems, and they were getting exhausted, and they were tired, and they were worn down. And they were probably sick of fighting with each other for months in the sweltering hot, Independence Hall in Philadelphia. And so for a variety of reasons, they more or less punted on it. It's known as the Madisonian Compromise. And that they said that the first Congress would be the ones to really determine all of these details of the federal judiciary, which makes sense because those people were actually elected by the people, by Americans. Whereas, remember, the men at the Constitutional Convention were not elected by anyone. They were just like some really smart, mostly social elites who just went to Philadelphia to, see who the best debater was. And so the Constitution elaborated in Article 3 neither the exact powers and prerogatives of the Supreme Court nor the organization of the judicial branch as a whole. Thus, like I said, it was left to Congress. Now, it did say that there would be a Supreme Court. It also mentioned that there would be a Chief Justice, but it made no specific mention of how many justices there should be on the court at any given time. Now, when the first Congress was put into place following the ratification of the Constitution, they passed the very first bill that they passed in 1789 was the Judiciary Act of 1789. It was the first bill introduced and the first one passed in United States history. This created 13 judicial districts, 3 circuits, Eastern, Middle, and Southern. It said that the Supreme Court would be at the nation's capital. And it also said that there would be 6 total justices, a Chief Justice and 5 Associate Justices. John Jay was the first Chief Justice. Now, the Supreme Court back in the late 18th century was very different than the Supreme Court is now. It was a good job, depending on who you asked, but nothing like it is today. I mean, saying it's a good job is actually being pretty generous. It was very difficult for men like President Washington, President Adams, and even President Jefferson to a certain extent, to find men, mostly Washington and Adams, though, more than Jefferson, to find men who were qualified enough to serve on the Supreme Court who actually would do it. In fact, many appointees who did accept the job only stayed for a couple years because they were like, this sucks. I don't want to do this. This is no good. They would usually resign and look to potentially get another role in government like John Jay did. He left to become the governor of New York. Like no Supreme Court justice would ever leave to become a governor of a state today, most likely, right? Or they would leave, and this is even worse, they would leave to serve on their state Supreme Court because they actually could hear better cases and have more of an effect on things on their state Supreme Court. And in many ways have more power, like the state Supreme Court of New York or the state Supreme Court of Virginia have more power than the U.S. Supreme Court at this time. Now, in this Supreme Court, it was very important that they were able to maintain some type of independence from the political goings-on within society. So they have a lifetime appointment, and their salaries cannot be lowered while they're on the bench. Therefore, you can't use the power of the purse in Congress to, threaten them in some way or influence their decision-making. And you can't threaten to fire them because they have, as long as it's good behavior, they have a lifetime appointment. These early Supreme Court justices would complain all the time about the limits of the court because it just didn't really have very much power. We'll talk about the inconvenience of like riding the circuit. That was another thing they complained about. But look, this is what the founders wanted, at least some founders. Alexander Hamilton wrote in the Federalist 78 how the judiciary branch of the U.S. government would have, quote, neither force nor will, but merely judgment. Right? Well, that's not quite how it is today, Alex. Sorry, man. It didn't work out the way that you had hoped. I mentioned John Jay resigned to become governor of New York in 1795. Well, in 1800, when before John Marshall was put in place as Chief Justice, when John Adams was doing those midnight appointments, I mean, this shows you the quote quote power of the court. He was begging John Jay to come back, like, please come back, and John Jay was like, no, thank you, I'm done. I did my 6 years. I don't want to do it anymore. So, with the Midnight Justices, following the election, the, quote, revolution of 1800, as some historians call it, to make something not particularly exciting sound very exciting, John Marshall became the Chief Justice of the Supreme Court. He served for 34 years. Many of his colleagues served for over 20. And he established judicial review through Marbury v. Madison. Now, we have already had an episode on Marbury v. Madison in which yours truly and Bill really nerded out for like an extended period of time over this court case. It's episode 90.
I remember it being part one of, if not the best episode in the litany of episodes.
Yeah, with you in it, for sure. Yes. It was episode 93. If you don't want to search through the catalog, you can go right to episode 93. So I'm not going to dive into huge detail on Marbury v. Madison, but I am going to take just a couple minutes and review it, and you know how hard that is for me. So I've talked about how Article 3 of the Constitution did not lay out really the framework of the federal judiciary, not just for the Supreme Court, but the federal judiciary, like, at all. Well, it also, through the Judiciary Act of 1789 and the limits of Article 3 of the Constitution, the Supreme Court really didn't have much power to do much of anything. That's why no one wanted to serve on the Supreme Court, because their decisions were not going to be very influential. They were, for all intents and purposes, primarily just the highest appellate court in the country for federal cases. But back then, most cases weren't federal cases. Most cases were state cases. So they really didn't see a lot of impactful cases. Now, everything changed for the Supreme Court following Marbury v. Madison. This is the case in 1803 that would change everything. And this is what put the judicial branch, i.e. the Supreme Court and all the other federal courts, on somewhat equal footing with the executive and the legislative branch. Like I mentioned, if you want to go really into detail, episode 93 is something you'll want to check out or re-listen to. So what happened in Marbury v. Madison was during the midnight appointments for John Adams. And for those of you who don't remember, John Adams, we're going to have that special episode on incumbency advantage. Well, the Adams family would call BS on that because they both lost their attempts at re-election. So after John Adams lost to Thomas Jefferson in 1800, he wanted to create some type of lasting Federalist legacy because he saw the Federalist Party was dying and this wave of Democratic Republican revolution was coming in with Jefferson. So he increased the number of federal judges and just appointed a ton of Federalists to those seats. Some would call that, I don't know, like court packing. So it's been done in a lot of different ways, right? It's been done in a lot of different ways. Now, one of the men that Adams had written and signed a commission for was a man named John Marbury. Well, John Marbury never got his commission because when Jefferson became president, Madison was his Secretary of State. Technically, Madison was supposed to be the one to deliver the commission, and Jefferson and Madison were like, oh, look at that. Adams and John Marshall forgot to deliver the commission. Oh, shucks. I guess we'll just have to misplace it and act like it never happened. Well, Marbury argued that the moment John Adams signed his commission as sitting president, he deserved that seat. So he was suing, and he was suing James Madison, who was Secretary of State at the time, and was taking it to the Supreme Court. Now, the crazy thing at this time is that John Marbury took this case to the Supreme Court. Thomas Jefferson and James Madison didn't even bother showing up. They didn't even send surrogates. They cared so little about what the Supreme Court under the new Chief Justice, John Marshall, was going to decide in this case that they didn't even bother sending, like, a lackey, like, just to be there to argue some stuff, some, like, slick-haired lawyer, just, like, to start spewing nonsense like most lawyers do when they know they don't have much of a case.
Preach.
Yeah. And so that shows how little they thought about the Supreme Court. Now, Chief Justice John Marshall, who was very tuned in to what was going on here, because he technically was the one that was supposed to deliver the commission to Marbury when he was Adams Secretary of State. Now he's Chief Justice of the Supreme Court and he's hearing the case. So, I don't know, a little bit of a conflict of interest. But John Marshall believed that, look, sometimes the president has discretion over decisions they can make, but other times they do not, because they were mandatory actions by law. So, with that in mind, John Marshall believed it was his court's duty to review what type of decision-making authority or lack thereof did Jefferson and Madison have here. Could they truly decide whether or not to deliver the commission, or was this something they really had to do, they were obligated to do? Now, you may be wondering, why is this case in the Supreme Court? That would be a good question. If you think, well, I thought the Supreme Court was mostly an appellate court, why is Marbury going right to the Supreme Court? And today, the Supreme Court mostly is an appellate court, and technically back then it was too. But in 1803, John Marbury was arguing that even though the Constitution doesn't give his original jurisdiction in the Supreme Court, the Judiciary Act of 1789 said that through the writ of mandamus, which is something we won't go into detail of, but Marbury argued that through the Judiciary Act of 1789, he believed he could go right to the Supreme Court. Original jurisdiction just means the first court to hear the case. And that's what he argued. And it did, sort of, but not really. So, what Marbury was telling Marshall is that I want you to decide that when there's a conflict between a law or statute, like the Judiciary Act of 1789, and the Constitution, like, do I have original jurisdiction or not? And then if I do, can you issue the writ of mandamus? I think you should be the one to make that decision, Chief Justice Marshall. You should be the one to decide that. And you should be the one to decide what type of decision-making authority Jefferson and Madison have here, because I think they're mandated to give me the commission. And so Marshall was like, okay, sounds good. That sounds like an argument I'm interested in, because, wow, that sort of indirectly gives me an enormous amount of power. And so Marshall embraces Marbury's argument and determines that a part of the Judiciary Act of 1789 was unconstitutional, thus giving the Supreme Court the power of judicial review. That power, quite simply, is the power to determine, basically call balls and strikes on the constitutionality of an action by the legislature or the executive. That was not originally intended to belong to the Supreme Court. So when you think of these huge cases like Dred Scott, Brown v. Board, Roe v. Wade, right? The Heller decision, Citizens United recently, which have a ton to do with our elections. These cases, technically, originally, should never have really existed under the founders' view of what the Supreme Court should be doing. But that all changed with Marbury v. Madison. So the Supreme Court all of a sudden became an somewhat equal member of the three branches of government, which then increased the scrutiny of the men, at that time only men, serving on the court. What their political leanings were, what their views on the Constitution and society and politics were, because now all of a sudden, these men could technically veto, more or less, or invalidate an action by the president or by Congress, which was something that before Marbury v. Madison, they never had the power to do. And as I'm sure Bill is impressed that I just summed up Marbury v. Madison in like 5 minutes, which not easy for me. So Bill, I'll kick it back over to you. Why don't you give a little more now that we have a better understanding of where the court came from, what its original intention was, and how Marbury v. Madison flipped all of that on its head, why don't you walk us through some of the changes that the court went through early in its history?
Yes. So Chris touched on the Judiciary Act of 1789. I'm going to reset the table to give you all a clean chronology. But first, we're gonna jump to present day. And so I have this thought. Right now, there may be a thought in your head to the tune of But I've been hearing a lot about how a different number than 9 justices would be a radical departure. That thought is a logical one. However, with greater context, you may end up coming to the conclusion that it is only radical if we ignore all of the other times that the numbered composition of the court changed over the last 240 plus years. To reiterate what Chris addressed a little earlier, but it bears repeating, the Constitution vested the judicial power of the United States in one Supreme Court. While it was quite specific as to the types of cases and controversies SCOTUS was to preside over, it was, however, silent as to what the court was to look like. It was the Congress that established in the Judiciary Act of 1789 that SCOTUS was to be made up of 1 Chief Justice and 5 Associate Justices. Now, check my math on this one, Chris, and you've already done it because I just heard you a couple minutes ago. But by my count, I have SCOTUS at 6 total justices. Is that right?
Yes.
Okay. So this is a rhetorical question, Chris. Please don't answer this.
Okay.
And actually, I'm not going to even answer my own rhetorical question. But is that radical? Then, in the Judiciary Act of 1801, a hyper-partisan move by the Federalist and outgoing President John Adams reduced the number of justices from 6 to 5 in an attempt to limit Thomas Jefferson's ability to exert political power through SCOTUS appointments. The law was subsequently repealed and therefore much ado about nothing, but it is evidence that the number of total justices is a moving target, and politics have very much something to do with it. Geographic expansion by the United States drove the corresponding increase from 6 to 7 justices in 1807, and again from 7 to 9 justices in 1837. The sheer distance in the expanded national boundaries required additional circuit courts to be established, and those new justices to traverse far and wide. And right here, Chris, you mentioned it a bit earlier.
Yeah.
We're gonna transition back to you, and I think it's frankly it's kind of funny to me, but could you please explain what I meant by these justices having to traverse far and wide?
Yeah. So as I mentioned earlier, that the early justices on the Supreme Court weren't like over the moon at the appointments to the Supreme Court, not only because of the reasons I mentioned, but in addition to that, there was another reason. They had to, quote, ride the circuit, as they would call it, in judicialese. In those judicial circles where the judges come together for late night beers to talk about judicial theory, they would talk about, I have to ride the circuit next week. But what that meant is that they had to ride on a horse and buggy, right? And a horse and buggy, or sometimes just on a horse, on terrible roads, right? Like late 18th, early 19th century roads all across the states, sometimes in awful weather, like super cold or super hot, all over the country. So they could hear these cases multiple times a year. They would have to do this. It's almost like touring, like a band, like touring the country, right? In a horse and buggy. And so they would often stay in these bug-infested lodgings when they were on the road. And they weren't shy about how terrible this was. I mean, they would complain to each other all the time. They would write letters home. They would complain to Washington and to Adams how terrible this was to ride the circuit. And they weren't now granted, there were other federal judges who, quote, rode the circuit. But you would think that the Supreme Court wouldn't have to ride the circuit. And actually, and this isn't really chronologically related to what we're talking about, but the Supreme Court for the longest time didn't even have their own building. It wasn't until Taft became the Chief Justice, who used to be the president and was got used to hanging out in the White House and having his own, place to hang, that he demanded there be a building for the Supreme Court. They actually just operated out of Congress for the longest time, which not really pertinent to anything we're discussing, but I thought worth bringing up. So Once again, another trivia fun fact. I'm going to make people so much money one day if there is a trivia game with all of the specific things I mentioned throughout this podcast. But you mentioned, Bill, so that's it. That's riding the circuit. That's another reason why no one wanted to be a justice.
So it is kind of funny. I mean, that's kind of funny.
Yes, as I sit here in my air-conditioned house, talking to you, looking at you through Zoom and recording this, and it will be blasted out to tens of thousands of people in a matter of hours through the internet. It is kind of funny for me to sit back and think about just a couple hundred years ago.
Hold on. But it's really the juxtaposition of like the court as we view it now and the court as it operated then.
Yeah.
Like it is bananas different. I mean,
yes.
There's a lot of stuff that's different, but that's way different. And that, to me, that's kind of fun.
I'm not sure on a scale of 1 to 10 how different bananas different is, but I would assume it's closer to 10 than 1.
It is. You'd be correct.
I would have to agree with you. Now, Bill mentioned that the size of the Supreme Court went from 7 to 9 in 1837, and it stayed there for a while as we approached the Civil War. Now, it will change again, which Bill will get into, but I think it's worth bringing up one of the impetuses for that change, and that was the Dred Scott case. Now, I am not going to go into great detail on the Dred Scott case, just like Marbury v. Madison, because I am sure, and Bill will likely be you, I'm sure we will do an episode probably dedicated to Dred Scott, just like we did Marbury v. Madison, because it was such a landmark Supreme Court case, and it makes me want to bang my head against the wall every time I read about it, but a lot of things in American history do. So, it was in 1857. In short, Dred Scott was a slave who lived in the slave state of Missouri due to the Missouri Compromise from 1820, which said Missouri would be a slave state, and was sold to an army doctor. After being sold to this new owner took him to the free state of Illinois. Now, under both federal law and Missouri law, Dred Scott now believed he had the right to his freedom, and he had a very good point. So he sued for it. Now, since he had been given over to this doctor, the doctor had passed away, and then his wife wanted to remarry, and she wanted to remarry like an anti-slave guy, and he was a politician, so he couldn't be seen marrying a woman who owned a slave. So then she actually gave it to her brother, Dred Scott, to her brother, and his last name was Sanford. And that's why it's Dred Scott v. Sanford. So when Dred Scott brings the case to court, this guy Sanford technically owns him. And it just sounds like wrong saying that out loud, but you know what I mean. So since there were two different states in the mix, because this Sanford guy was from New York and actually did some business in Missouri and in St. Louis, because there were two states involved, Dred Scott was from, when he began the suit, he was in Illinois. Now it's a federal case. So it ended up going to the Supreme Court, and in a 7-2 ruling, the Supreme Court said that Dred Scott was not a citizen of the U.S., so he didn't have the ability to bring the case in the first place. That's the first thing Roger B. Taney, the Chief Justice of the Supreme Court, said. Not only that, but he also said the Missouri Compromise, which established these like free and slave portions of federal territory, technically was unconstitutional, because if you say that a federal territory is free, that would mean someone could not bring their slave. And since technically, under American law at this time, slaves were property, that would be a violation of your Fourth Amendment right to personal property. So, Roger B. Taney, like I mentioned, was the one who wrote this opinion, and this opinion is the biggest load of garbage that you may ever see in the history of the Supreme Court. It's truly, truly an awful decision. And I'm not even talking about like the moral depravity of the decision, but just the sheer obvious contradictions it lays out. It was just terrible. It was just terrible. And the terribleness of the opinion is important here. So without getting too deep into the weeds, what Taney said was that if you were black, you could not be a citizen of the United States, right? When he said that Dred Scott could not possibly bring the case to him, it wasn't just that he was a slave, but the fact that he was black, the fact that he was African American, meant he couldn't bring it. It wasn't just like his legal status of being a slave. And that didn't make any sense because in 5 different states, African Americans could vote, hold property, and basically fully participate in society. So that just wasn't in any reality true. And on top of that, Taney then continued that the reality of, and like this is actually written in a Supreme Court majority decision by a former Chief Justice of the Supreme Court of the United States of America, Roger B. Taney continued that the reality of African Americans being inferior to whites was a universal belief and that it was fixed and something that would not change. He claimed, with, of course, zero evidence to back it up, that the founders believed this and that this is what they intended. Like I said, zero proof for that argument. Now, the interesting thing is Taney was a slave owner. He was from Maryland. I don't like to admit that. We've mentioned it before. He was a slave owner who actually seemed to be like one of the more benevolent slave owners. He had freed his slaves. He's not like your hardcore pro-slavery guy. At least it wouldn't seem. But the Democratic Party to which he belonged had gone so far in that direction that he went with it, right? And this is where, in the end, these people are human. So the problem is that the reaction to this decision is what you would have expected at the time. Southerners overall were really excited about the decision and felt it was vindication for, owning other people and continuing to profit off of their labor and early death. In the North, though, the Northerners, abolitionists, Republicans, were furious about it. They believed that the dominance of the Democratic Party in the Supreme Court, the makeup of the 9 men in the Supreme Court, were so overwhelmingly pro-Democratic Party and thus likely to be much more pro-slavery than maybe they otherwise personally would be, like Taney is a perfect example, that it was critically important that everyone understood that, because that was one of the things that was holding America back from progressing in the way it needed to, specifically with regard to the rights of African Americans. Lincoln spoke out publicly against this decision when he was running for office, and he used his criticisms of the Dred Scott decision and Roger B. Taney's heaping pile of trash of an opinion to actually become very popular in the North and eventually lead him to really competing with Stephen Douglas in the Senate race in Illinois. Stephen Douglas was like a political rock star at the time. Abraham Lincoln was sort of a nobody. And then it propelled him, of course, to win the election of 1860. On top of that, because of the Dred Scott case, that's partially, and for some people a big reason, why they had to add the 13th, 14th, and 15th Amendments to the Constitution, ending slavery, giving African American citizenship, and giving them the right to vote. Because it was so incredible to many that Roger B. Taney would lay down such a blatantly prejudiced decision like this. They literally needed to amend the Constitution to take the power of judicial review regarding the rights and privileges of African Americans as real people in our society away from the Supreme Court. Now, this decision and how it relates to what we're talking about here really hurt the legitimacy of the Supreme Court, and also helped to push a narrative that changing of the makeup of the Supreme Court would be justified, and that's where we lead to the next change in the size and scope of the court.
So we've got the Dred Scott decision, the Civil War, and then westward expansion, but jumping back into the narrative and the chronology here, Chris, provided Abraham Lincoln as president with the, I guess you could call it an excuse?
Justification.
Justification. To increase the court's size from 9 to 10. 10 justices. However, after Lincoln was assassinated, the Republicans in Congress feared that what Andrew Johnson would do to SCOTUS. Andrew Johnson had already vetoed the Civil Rights Act of 1866, although the veto was ultimately overridden. Johnson was also sympathetic to the southern states that had been attempting legal, I'm doing air quotes around legal means to restrict the freedoms of newly freed, formerly enslaved peoples. The Congress passed in 1866 the Judicial Circuits Act, which reduced SCOTUS from 10 back to 7 justices. It really pays to control the Congress in all of these instances. Now, depending on your view of history, this could be viewed as another example of naked partisanship and its impact on SCOTUS. But wait, there's more. Because once the Republicans regained the White House with Ulysses S. Grant just 3 years later in 1869, the Congress increased the number back to 9 from 7. Shocker, right? And so at 9, it would stay through the end of the 19th century and well into the 20th century. That is until 1937, when President Franklin Delano Roosevelt took issue with the Supreme Court that was at odds with the New Deal legislation that the Democratic Congress passed and FDR signed into law. In February of 1937, FDR floated an idea that would have allowed him to appoint a new justice to the court for a total of up to 15 justices for every justice over the age of 70 who opted not to retire. To FDR, the conservative bloc of justices was known as the Four Horsemen. Now, Chris, I'll give you 2 guesses as to what age each of those 4 exceeded, as did the Chief Justice. You'll only need 1 guess, I suspect, though.
I will go with 70.
You would be correct. The youngest of the 4 was 72.
God, I'm good.
Now, while FDR's court-packing plan, I'll go court-packing in air quotes as well, never took off and was generally unpopular, if we're all being
it was one of the most unpopular things he did as president.
So
he was president for like 100 years, so I mean, like he's president forever.
You know my personal subjective thoughts on FDR. So saying that this plan was generally unpopular, really, it was really big of me.
Yeah, that's good.
It was generally unpopular both in Congress and among the public at large. Actually, that's also another point to make. It's that it was both politically unpopular and the public at large didn't care for it either. It did have one immediate, seemingly causal effect, though. After FDR's plan went public, Associate Justice Owen Roberts, who was viewed as one of the swing votes on the court, well, Justice Roberts decided to start upholding New Deal legislation that the court had previously been holding as unconstitutional. So much so that Owen Roberts' change of heart is often referred to as, quote, the switch in time that saved 9. And so again, Chris, this is a rhetorical question that neither you nor I need to answer. Was FDR's court-packing plan radical? Actually, wait. You know what? I'll hedge a bit, and I'll say perhaps. To many scholars, FDR's court-packing scheme was a resounding failure. Certainly at the time, that's what the news impression was and all that kind of stuff. But, however, based on FDR's New Deal legislation success after announcing the court-packing scheme, I still find it difficult to consider that the gambit at least wasn't a partial success. Now,
I would say, in retrospect, which is the type of analysis I like doing the most.
Amen.
In retrospect, it was an enormous success. Of course, it was. He continued to be president. It didn't affect his chances at re-election. And what it was if it was a gentle reminder, not so subtle reminder to the Supreme Court, that, sort of like a who's your daddy? All right. Like last time I checked, buddy, if I can get enough of these politicians in Congress to go along with me, I can totally change the entire makeup of the Supreme Court. Not really but Congress can totally change the entire makeup of the Supreme Court. And so if you're going to continue to stonewall what FDR believed the people wanted, right? If society has moved on from your views of the world because you're 75 and the average age of the electorate is nowhere close to that, and you don't get up with the times, then we will just change the makeup of the court and make your vote far less valuable and maybe even totally worthless. And so it's a shot across the bow for those reasons. And that type of leverage is incredibly powerful for a president and a Congress to have, especially when the president and both houses of Congress are all from the same party. Now, moving away from our narrative real quick, and I'm not going to get into my opinion on any of these things, but looking at it from that perspective, Bill, and I don't know when you'll be listening to this in our narrative, but in October of 2020, as Joe Biden, former Vice President Joe Biden is running against President Trump, there is a very big discussion about this idea that if former Vice President Joe Biden wins, becomes President Joe Biden, and the Democrats take Congress, there will be quote-unquote court packing, right? That was the impetus for this entire episode. That, along with the Republicans beginning their proceedings for Justice soon-to-be, I think, we'll see, Justice Barrett tomorrow, right? The reason why politically I would think someone like Joe Biden or Kamala Harris, who both of them have refused to answer the question on court packing directly, is because in their mind, potentially, it could give them a significant amount of leverage moving forward with the Supreme Court to keep all their options on the table. Just like FDR did when he told the court, hey, don't forget, if you continue to stonewall me through these things or make Congress's life too difficult, or from my perspective, the lives of the American people, we can just whole cloth change this thing up and make it so we are able to get these pieces of legislation passed. And I think that's just it's just naked politics. Like, that's the type of thing. Like, why would you give up that type of leverage if you don't have to? Now, if former Vice President Joe Biden or Senator Harris thought that by admitting or saying that they want to, quote, pack the court or change the numbers of justices would lose them the election, then yeah, they would not say that, and they would go 180 degrees the other way to make sure they won the election. But their political calculus is that admitting it or not admitting it, totally avoiding the question, is not going to cost them the election. So if totally avoiding the question is not really going to move the scales on the election, then why answer it? Because you're only, like, if you can't do something like FDR did in 1937 to try to change the outcome of some of these cases. And we know that a guy like Chief Justice John Roberts cares very much about Congress staying out of his business and the president staying out of his business and his court's business. So anyway, like I said, we don't give really our opinions here, but like from just a purely analytical perspective, hopefully that helps you maybe better understand some of the reasons why this is such a hot button political issue now, and some of the reasons why Harris and Biden are avoiding talking about it, and some of the reasons why Trump and his surrogates and Pence want so desperately for them to commit to something. Because if they commit to something, they lose all their leverage one way or another. So.
Yeah, so
anyway.
Spoiler alert, it stayed at 9 since FDR's threat to take it to up to, in his defense, up to 15, not necessarily going all the way there. But yeah, and so I just want to end my portion. Primarily, that was the chronology of the changes, the numerical changes. But I just want to end my portion with this, that the Constitution is silent on how many justices there are. SCOTUS, since its foundation, has fluctuated from 6 to 5 to 7 to 9 to 10 to 7 to 9. And so I'd leave you with several questions that I think are worth asking yourself. And given the framework that we've introduced, given what you see in the news every day, I think they're particularly relevant questions. So is it radical to contemplate or enact legislation to change the number of justices going forward? Is it radical that a change would be done for purely political reasons? Is it radical to suggest that the court must stay at 9? These are questions that I don't know if I'm necessarily equipped to answer. We don't, like you said, we're not necessarily pundits, Chris. However, I will say, I think there is a strong argument to be made that an institution that was never strictly drawn, that has a legacy of mutation, is amenable to change. And that's the thought I'll leave you with.
Yeah, and I actually think you would be hard-pressed to find a lot of people who would whole cloth disagree with that. And I think what you'll come to find in future conversations about the Supreme Court is that it always has to do with the justifications behind it and how potent you think those justifications are. There's no one who's going to sit here and say, at least if they know the history of it, that it's totally radical, unheard of, and unfounded to change the number of justices to the Supreme Court. That being said, it hasn't been done in 160 years. So, it depends on what your definition of radical is, right? Because that's purely subjective, too. That's truly changing the foundation of something. Now, you could easily listen to this episode and say, well, it's obviously not radical. It's been done a whole bunch of times for a lot of different reasons. Or you could say, you listen to this episode and say, yeah, but the last time it was done was 160 years ago. And when a guy brought it up, when FDR brought it up 80 years ago, it was seen sort of radical back then. So that would make it super radical now, right? So you can really go one way or another. And when I think of the Supreme Court, I do think it's worth me editorializing a little bit here as we log off. It's important to remember that when we think about the debate over the Constitution, the judges from England had for so long, over centuries, resisted the urge to do anything but apply the law. That's what our founding fathers were used to. They often had pushback against the king, as you can imagine. But over time, they established the ethic that their beliefs about policy or justice shouldn't play a part in their decision-making. And good for them that they did. And this is one of the carryovers that we saw immediately in the U.S. Supreme Court and judges and lower courts, for that matter, in theory. And the issue really boils down to federalism. The question is where you want these issues about the future of our country being decided and who you want to be the ones to decide them. In 1789, following the ratification of the Constitution, you had the Judiciary Act. Now, following the ratification of the Constitution, no one knew what the staying power of this Constitution would be. And no one really knew what type of impact the judicial branch would end up having on the United States, which is why they left so much up for debate. The debate, there's nothing wrong with the debate itself. Making these considerations in general, on principle, there's nothing wrong with that. That's technically what the Founding Fathers wanted. They wanted the people's representatives to make these decisions. Of course, like I said, you have to take context and current circumstances into account with all of these conversations. That would make you maybe feel like in this certain circumstance or others, it was wrong, right? And that's up to you. Now, this specifically is exactly what helped create the controversy we're currently experiencing. Because so little was outlined about the court within the Constitution, it has been a political tool for quite literally the entire history of its existence. And this is the point I really want to drive home here. The Supreme Court is not apolitical. The Supreme Court is political. Now, the Supreme Court technically was set up not to be political. They message to you that they are not political. They wear all wear black robes. They deliberate in secret. There are no cameras in the courtroom. It is not the political circus that many other parts of the government truly are. So for that, they deserve credit, I guess. Whatever. But this is where the tension exists within American society when it comes to the Supreme Court. And there are seemingly legitimate arguments on both sides. One is the desire of the court to be democratic and further the progress of society and its people. And that makes sense to a lot of people. Usually, those people are more liberal. While the desire of the court to be non-democratic and leave all progress or decisions that impact society up to the other two branches of government has its ardent supporters, and those tend to be more, at least with regards to this issue, tend to be more of the conservative thinkers. But in the end, while we like to think of it, and it likes to promote itself as a body that stands outside politics, the reality is it just doesn't. The other two branches of government play a key role in the court. The president nominates and the Senate confirms any new justices. Congress could reimplement the appeal of rights, which would then make the caseload skyrocket in the court and force them to potentially change the way they operate. Congress could also cut its budget if it wanted to. Congress could also change the number of justices on the court. So the court needs to be politically aware of what is going on. And since the court is made up of people with subjective feelings and emotions and pressures, they are just never going to be a body of people that is truly immune to the blowing of the political winds. We see it in the Dred Scott case, right? Roger B. Taney becoming much more radical with regards to slaves because of the direction that his personal political party was moving. We saw what just happened, right? Not what just happened, but what Bill talked about with FDR. All of a sudden, justice switches how he's ruling on things, right? And that's because they know where the bread is buttered. The Supreme Court does not have the power of the purse or the power of the sword. And that is critically important. The Supreme Court's power derives from its legitimacy. Its legitimacy is derived from Congress and the executive. If the president ignores the Supreme Court over and over and over again and refuses to execute upon its decisions, and or if Congress ignores the Supreme Court decision and continues to legislate in the face of it, and then the president executes that legislation, then the Supreme Court, for all intents and purposes, has lost its power of judicial review, which severely weakens it. If the rulings of the Supreme Court fall too far outside the movement of the people and the other branches, then there is potential they can lose their legitimacy that way. So in the end, as much as it pains me to say it, the court is political. The court always has been political. It always will be political. And the sooner people begin to realize that, the less tension there will be around our conversations regarding the future of the court. People will be able to stop pretending like it's not political. It is political. It always will be. And that's why it doesn't surprise me what has gone on recently with the Supreme Court. Because it is political, and it always will be. Thanks for listening, and hopefully now you can take pride in knowing just a little bit more about the history of the United States. Class dismissed.